Hi, I'm Melissa Gillis, and I'm an associate with Bacon Wilson, practicing primarily in the area of domestic relations. As many of you know, the child support guidelines Massachusetts utilizes in determining the correct amount of support one parent should pay to the other for the benefit of their child changed dramatically effective January 1st, 2009. And it's taken a while for people to understand the intricacies of the new guidelines, how they relate to multiple children, and also how the courts are going to deal with the issue of child support as it relates to college and the obligation of one parent to contribute to college expenses of a child. The new guidelines state that once a child turns 18, the guidelines technically don't apply anymore. That's created a lot of anxiety for custodial parents who are trying to make decisions with their child about which school to select and what the ability of the parties are to afford the college costs. What often happens is that a custodial parent is very used to receiving a weekly amount of child support, and they've based their living expenses and they've supported themselves and that child based on, in part, the amount received. So the idea of not receiving anything yet having the college costs paid for in part or in whole can be a very stressful time for custodial parents. And so oftentimes, either in a separation agreement from the parties' original divorce, or because the separation agreement or divorce judgment issued by a judge from a trial has not contemplated or decided the issue of college contribution, a modification action ensues. And in that modification, one party is asking for college contribution. Very often what happens is the other side, the parent who's going to pay, files a counterclaim for a reduction in support. And so what you end up with is a situation where the court has to decide. The very first thing that the courts are going to do is they're going to look at what the ability of each party is to pay. And they do that through looking at not only income of the respective parties, but assets as well. They also take into consideration any scholarships, available financial aid, or grants that a child could receive. And finally, the other aspect is what college the child wants to go to. Something else to consider is that if you have shared legal custody, you are entitled to participate in the decision-making process about where your child is going to go to school. And if you don't have shared legal custody, it's important to word in any agreement that you want to have or maintain some kind of control over that decision-making process. I'm Melissa Gillis. I'm an associate in the Domestic Relations Department of Bacon Wilson. And if you're either in the midst of a divorce, contemplating divorce, or have been divorced and have a child of college age that you need help working through these and other issues, please feel free to contact me.